Good morning and welcome to a debate on CIGA hosted by ourselves, Collyer Bristow. I'm Robin Henry. I'm the head of dispute resolution here at Collyer Bristow. And this is the second debate that we've hosted on the implications of CIGA. And I'm delighted to welcome back the exact same team who participated in last year's debate about almost exactly this time last year. So I have here with me Colin Haig, who is head of restructuring at Azets and is currently also the president of R3. Jeff Roberts, who is my partner at Collyer Bristow and is the head of corporate and commercial services. Stephen Baister, who is a deputy insolvency and companies court judge and formerly a chief bankruptcy registrar and currently with Manolay Partners, and Lee Manning, who is a partner at Resolve Group UK. And also finally, not last but not least, Malcolm Weir, who is director of restructuring and insolvency at the Pensions Protection Fund. So we've got quite a few issues facing us in relation to the current situation with CIGA. And I'd like to kick off by raising the issue of moratoria. And I'd just like to maybe ask Lee to give us a few examples, if he can, of situations in which the moratorium has proved useful. And I think this, has been a sort of a patchy start for the moratorium. And if he could show us perhaps how it has become useful in practice.
Okay, thank you, Robin. I mean, first thing is it moratoriums or is it moratoria? That's a question for Stephen Baister, I believe. He's suitably schooled in Latin, and so that will be something for Stephen to ponder about whilst I sort of dive into the meat and drink. Yes, I think there were only 4 used between June 2020 and December 2020. The challenges or the speculation was that they were cumbersome, expensive and onerous. And when would they be of practical use in terms of all of the hurdles one has to overcome, including that of having to meet the running costs of the company subject to the moratorium from the time that the moratorium is filed and until such a time as it is over. And that can be challenging and exposes the monitor to some risk there, as they're responsible for making sure that that happens. I've had the good fortune in the last few weeks of being able to put to practical use 8 moratoriums, all within a group of companies, but all essentially SPVs, or there is some sort of cross contamination of liabilities. And the important thing about why I think it's been useful is that these moratoriums have been put in place subsequent to us having worked for a considerable time pulling together CVA proposals, which were not finished at the time and are not quite finished at the time. And the rationale for using the moratoriums was because we'd reached a stage where we needed to protect the company from its creditors. We worked alongside the company's fixed and floating charge debenture holder, so they were fully aware of what was going on. Their own separate advisors at the same time. What has happened is that most of these companies, indeed all of them, they're in the serviced offices industry, and they've got a number of large buildings with massive arrears for business rates and for rent, really absolutely caused by COVID, where they simply lost their tenancies as people moved out, no one moved back in. And we've been working on pulling together, but the trouble was that the whilst there's obviously been a moratorium on winding up petitions, there is no moratorium on local authorities obtaining liability orders and then enforcement orders and bailiffs turning up. So whilst the company on the drip had been able to keep some of those bailiffs at bay, they were starting to turn up unannounced and in large numbers, and exposing the company's very significant physical assets to uplift, distress, and causing stress to the people working on site. And we realized that even if the notices of the CVA proposals were sent out, that would not protect against these guys doing their stuff. And they're pretty hard-nosed. They don't understand the law. They're not interested in the law. So it's actually worked to very good effect, because what it's done is put a fence around the company now, but it's really an addendum to the purpose. The purpose is the CVA, the rescue of the company. So we're starting from a position where we know, we're pretty damn sure that we can rescue these companies, or the companies can be rescued through CVAs. It's not one of let's have a moratorium and think about pulling a CVA together and then worrying about all the issues that flow from that. So we knew we had the cash flows already, so we knew we could meet the liabilities as they fell due during the moratorium period. We knew there was a bloody good chance of the CVAs being approved. We worked most of that up, but it was taking time because there are a large number of companies and we wanted to get it right. And so we put the moratorium in place for that purpose. I would hasten to add a couple of things on that. One, I think it was yesterday, the enforcement officers still turned up and said they'd never heard of a moratorium and didn't recognise, even when we showed them that the sealing of the court of the moratorium, they said, oh, well, that's just sealing that you've applied for a moratorium. We don't care. We're going to take everything away. That's what you have to deal with. We managed to deal with it properly. And the other thing that you will find is that the company's registry don't know what they're doing either. They sent back a whole load of our forms. These were the wrong forms. Well, they weren't the wrong forms, they were correct forms. And when we managed to speak to them, they said, oh, well, we've never really dealt with many moratoriums. Not all people know what they're doing. One moratorium where the filing shows the filing of the notice of moratorium. Well, this is on a different case. And actually what's registered in there is the notice of the end of the moratorium, which took place 6 weeks after the date where they supposedly filed the notice of the moratorium. And yet that was the document that they filing of the notice of the moratorium. So don't rely on companies' house to assist you in this regard. But the process itself was not that onerous. Required a board resolution, required a consent to act, and notices to be filed. But in terms of, is it expensive and is it time consuming? I would say no. Is it worthwhile? Absolutely yes, but it has to be in the right circumstances.
Thank you. I think that's I think it emphasises how that it can be useful, but in very, as you say, very specific circumstances, and perhaps, you know, particularly in the situation of COVID, where you've got businesses which there's nothing wrong with them, or wasn't anything wrong with them, apart from the fact that COVID intervened. But thanks, Lee. I don't know if anybody else has any comments on moratoriums. Colin.
I think I'd just add that that's particularly gratifying to Haig, because the record will show that in the last webinar, Haig was very pro-moratorium, and a certain Mr. Manning saying they're cumbersome, they're expensive, they're OTT, they're not going to get used. So I haven't done one, and he has. So as far as I'm concerned, Manning, that's 1-0.
I hold up my hands, and you're absolutely right. But it's pleasing. I mean, that I think we do have to worry about, and this is one back to you, Colin, is how, and it's an adjunct to moratoriums, when we have the restructurings through CVA proposals, how we're all going to deal with HMRC now with their preferential status. Because I've heard, and I think Stephen Hunt published an article somewhere saying that HMRC's attitude is, because they're preferential, they insist on being paid in full, irrespective of whether they'd actually get paid in full if there were an administration. And the other challenge that we have is that I've got another case where we were looking at CVAs, and we were looking at a moratorium, where the problem is there are lots of floating charge assets, and HMRC would get a sizable dividend in an administration, But if there is to be a CVA, whilst that it's clear that that dividend at least plus more would have to be paid to them to get to put them on the, you know, to on the right side. The problem is that would use up a lot of the company's working capital. So I can see situations where HMRC is saying, well, look, you've produced a set of proposals, and in that, in your estimated outcome statement, you show that we would have got £250,000 in an administration. You're offering us 300,000 in a CVA, but you want us to wait to have it paid over 3 years. Well, not interested in that. Those are going to be very real issues, and I think some guidance from, I think some lobbying by R3 to government about trying to get clarity on the you know, supporting the rescue culture by HMRC, who've had this fall of becoming preferential, will be very important.
What I like about what this debate demonstrates, particularly, you know, the fact that there were strongly held beliefs last time, one way or the other, is the value the insolvency profession brings. We are innovative and we find ways to make find solutions, as opposed to worrying about the consequences. We always talked about, well, moratoria wouldn't work because of the liability, potential liability for the practitioner. Yeah. Here is a context in which there is a very definitive and defined purpose and an end. So there's no long tail liability for the practitioner.
Yeah, look, the R3 is very aware of the criticality of the HMRC relationship. I've been negotiating with them recently. They're very tough at the moment, which is what you want, isn't it? That's public money they're playing for. It's our money. So you want them playing hardball, and they're very good at it. So we are putting quite a lot of effort into helping them to understand the potential of the new CIGA processes, and at a senior level, we're getting some really good traction, I think. But as ever, mate, as you know, it takes a while to filter through to the people on the front line, doesn't it? But
takes a while to get through to anybody. They're filtered through.
They're busy people, aren't they?
Yeah. Yeah.
Just a couple of questions on the chat which have come through, and they're questions for Lee. And I think you may have answered them already. It's just as to whether or not it's the process which is hindering the take up of the moratorium, or the number of financial debts which are excluded. And another question as to what can you give a guide as to the costs involved? But does it put it off for SMEs? But I think you're saying that the process itself is not that cumbersome and a hindrance.
No, the process isn't that cumbersome. I mean, we had to move very quickly, and we got it done very quickly. That, you know, there are no long-winded reports or submissions. You know, you just file your notice in court. You do need to be comfortable, if you're going to be the monitor, that these companies can meet their liabilities. I mean, to the extent that there needs, in the event that the company was to fail and go into administration, it becomes a super priority expense, you know, the running cost during that period. But you know, you want to keep close to it. So I think, you know, if you go in blind, it takes a wee while. But if you've been working with a company, it's not onerous. It wasn't an expensive process. You know, the lawyers got it all done on 8 companies within a day. Directors passed the resolutions. We spend a lot of time. But remember, we've been working on these CVAs for quite a long time. So that distorts it to some extent.
Yeah.
It seems to be a good bolt-on tool, really, doesn't it? Rather than seeing something as an initiating tool.
Absolutely.
Exactly what you said, Lee. You know, it's part of a process that complements things that are already there.
Yeah.
Okay, that's great. Let's move on to another subject, and I'd like to bring in Stephen and Jeff here, and just ask about how you see things in terms of the current restrictions or lifting of restrictions or changes to restrictions on winding up petitions.
Yeah, morning, Robin. I'll kick off, I think, if I may, Jeff, and hand over to you a little later on the, particularly the landlord side of things, where I think you've got a few things to say. Well, when we gathered the last time, we were focused, I think, on one set of restrictions, which were largely to do with the COVID test. As the major hurdle people were having to overcome, or one of the hurdles people were having to overcome in order to get a company wound up. And as we all know, those restrictions have now gone, but they've been replaced by another set of restrictions that on one view could be said to be less onerous, but produce some rather odd effects. In order now, under the new Schedule 10, there are 4 conditions that have to be fulfilled before you can petition. And I'm not going to read them all out because I imagine they're by now relatively familiar. I'm just going to pick up on a few points that arise from them. First, as Jeff and I have discussed in the past, there seems to be a convergence now with bankruptcy law, the other way round to the processes we've seen over the last few decades, where corporate law is tending towards the bankruptcy end. In particular, for example, in the restriction of the ability to wind up unless you're claiming a liquidated debt, which has always been so in bankruptcy, but has never been so under the much wider winding up regime available. And there are all sorts of reasons for that, which we won't go into this morning. The second thing is that in addition to the statutory demand, which is still the main route I think most people adopt for proving inability to pay, we now have to produce this strange warning letter that tells people that a winding up petition is threatened and invites proposals from them. And it's only really if no satisfactory payment proposal is made within 21 days that, again, you're entitled to petition. And there's a peculiarity about that, obviously, in having to have 2 sets of documents just to get a winding up petition off the blocks, as it were. One also that has to be served in accordance with the rules of service, and one which I think has to be delivered in accordance with the rules of delivery. So watch out for all sorts of nitpicking points over that, I suspect. The invitation to make a proposal gives rise to the interesting question whether the unreasonable refusal by a creditor to accept the proposal will be grounds for dismissal of the petition in the same way that it has been in bankruptcy, although with very, very restricted success. I think when I was the chief registrar, I decided the only case in living memory where a petition had been dismissed for unreasonable refusal on the part of a creditor. It's very, very difficult to show, but is that whole area of law going to creep into winding up, or is it simply going to be a matter of, the slightly palm tree discretion of the judge hearing the petition on the day? We'll have to see, but my bet is there's going to be a lot of law floating around about this.
I think you're right, Stephen. I mean, acting for creditors, issuing winding up petitions, the debtor company wriggles and squirms and tries to find reasons why it shouldn't be wound up. It sometimes has to scrape the barrel to show that there's a genuine dispute. A dispute is mentioned and its genuineness or otherwise is easily dealt with, but the grey area of whether an offer is reasonable or not, we're sort of almost straying into the restructuring tool, the counterfactual will have to be conducted to work out the alternative, the relevant alternative.
Another direction indeed, Jeff, that the law could take us in. I get swathes of expert evidence on reasonableness in the light of the economic performance of the company. And so, who knows? Yeah, no, it's a very...
And the elasticity of supply and demand, requiring economic advice and evidence as well.
I can see you're dying to have a go at this, aren't you? So, a case of, I'm just following on from that as well, Jeff. Of course, we now have the £10,000 limit, which I think is really pretty high. It's higher than the bankruptcy limit. And I can remember one of my predecessors at the court always saying with a twinkle in his eye, arguably, the smaller the debt the company can't pay, the more insolvent it is. And he was joking because, of course, you know, insolvency, it's a binary thing. You either are or you are. But you see his point. 10,000 quid is an awful lot of money, and it potentially restricts, it seems to me, access to the winding up process by a lot of small, medium companies owed bona fide debts by ghastly companies who just won't pay, particularly now coupled with the very high deposits and so on that have to be paid. So I've got worries about that. But the last one I'm going to raise, Jeff, which I hope is going to lead us on to something I think you're going to discuss, is the excluded debt provision. The exclusion, I think, pretty much for the first time, of a single category of unsecured creditor from access to the courts, and the imposition on that creditor of an alternative regime. And that, I know this is only temporary. I know Paul Bannister's listening out there somewhere as well, so I'm going to be careful. But this does seem to me to be a potentially dangerous incursion, as have been others in recent years, I'd have to say, on the class nature of all, or certainly the majority of insolvency proceedings. And that worries me intellectually, but it also worries me practically for the long term. I hope I'm being fair in recognizing the temporary nature of the present restriction. I just hope a lot of these don't find their way into the permanent law because of the reservations I've expressed. But others may disagree with me. I mean, Jeff, you may disagree with me. It may be others on the panel or even in the audience think I'm talking complete twaddle. It wouldn't be the first time.
I think just a quick point that I mean, these are temporary restrictions. They're only due to last until the end of March.
Yeah.
So it remains to be seen whether or not they represent a sort of trend towards more permanent legislation. But and if they do, I hope that, you know, a bit more thought is given to permanent legislation if we are moving down that track, which may or may not be a bad thing if it sort of converges more with bankruptcy. But it definitely, they have the feel at the moment of very much temporary rules, and
they do indeed, Robin. But as all lawyers will tell you, income tax is a temporary remedy for the Napoleonic Wars.
I mean, look, the commercial rent coronavirus bill is going to have a longer tail than the other restrictions, which are currently due to end on 25th of March. The restrictions, particularly on landlords taking remedies against tenants. Its current status is the bill is currently in the House of Lords having its second reading, so it's going to be a while before it becomes an act. But there is a shelf life in it, because any arbitration under the what will then be the act has to be conducted within 6 months, and concluded but within 6 months of the application. So once the bill is in and landlords can make demand and the tenants can put their proposals, the 14-day period for the proposals, the 14 days for the reply, and then a further 14 days within 28 days of the initial start, the reference to arbitration can be made. It has to be done within 14 days. So there is going to be a relatively short shelf life for that. And of course, it only affects rents that for periods where the tenant could not operate by law, and couldn't open for business in whole or in part. So it is very, very restricted, but it does provide a framework. And actually, you know, we talked in our podcast, Stephen, about whether it was adding another layer of expense. But the process in the bill is for the proposals to be outlined before a reference to arbitration can be made, and time for a response, and only if the response isn't made a 28-day period before the arbitration, does allow the parties to exchange views. And the requirement for evidence of viability and hardship does mean that tenants will have to be much more assiduous in bringing and transparent in bringing this evidence, rather than, you know, what's happened in the past where they've just said we can't pay. And it is up to the parties to actually agree. And having put the proposals and the counter proposals, and the arbitration application itself has to be accompanied by a proposal, it is hoped that the parties will manage to agree something without the layer of expense of having the arbitrator.
Yeah, I've just seen actually on the screen, there's a question put to me about the two documents where I was talking about, and I just wonder whether I wasn't terribly clear. The two documents I was meaning was, first of all, a statutory demand in the circumstances where you have to serve a statutory demand, and that might not be every circumstance. But now, under Condition B of Schedule 10 of the new CIGA schedule, I was referring to now the warning notice, it's called, which is now a precondition as well. So there are potentially, but arguably not always, two documents that a creditor for debt might have to serve.
Thank you, Stephen, for clarifying that. Jeff, just a question about remedies against tenants. What protection is there for guarantors? Some guarantees are very widely drafted.
From James Money. An interesting question, because most guarantees will provide that the guarantee can seek recourse without having to run all the other processes. I would have thought the landlord would be in difficulty in going straight to a guarantor under this process. The bill, I've just been, while I saw James's question come up, I've been frantically reading the bill, and there's nothing in the bill about guarantors. But I think that's probably a useful one to think about. Anyone else have any other views?
I'd just add, Jeff, that one of the huge disappointments for me, and I'm sure many, remains how little has been done in all the CIGA legislation to help individual debtors, and the overlooking of guarantors who can normally attach themselves to the rights of the primary obliger, or often can, is odd, isn't it? That you'd be able to go after the guarantor whilst having to go through a procedure that's potentially more onerous to get the rent from the person who's primarily liable. It's true. And
I guess the question would be how much is owed under the guarantee, because the amount that is owed is the amount that the arbitrator assesses is due. I
mean, I think it may also depend on whether or not the guarantor, in inverted commas, is simply a secondary obligor in terms of only owes what the tenant owes, or do they have a primary obligation themselves? In which case, they may well, not be bound by any arbitrator's decision to reduce rent arrears. So, but we'll see what happens with that.
I've got to confess, I'm unclear about that, Robin. That might be a whole debating session in itself, with an awful lot of law involved.
Okay. Anybody else got any points to raise about the arbitration scheme? I mean, it seems to me that there are, as Jeff was saying, it is quite restrictive in terms of who is actually eligible. You've got to show that you are, on the one hand, that you haven't got too much money, that you can't pay all the arrears back, and on the other hand,
you are
have
viable.
to show that you're viable, that you're
Yeah.
not actually insolvent. So there's a sort of a narrow band between those. Colin.
Just an observation, which is that, you know, the poor old arbitrator's got to find an answer to the viability question in a very compressed timescale at very modest cost. And I know how difficult it is when reporting to the debt on whether or not the underlying covenant is viable. It's tortuously difficult, and you know, a model is not the solution. Frankly, you know, models can be constructed to say most things, can't they?
Yeah, I don't know how. Does anybody have any information on whether the government is being successful in, you know, recruiting enough potential arbitrators to do this?
I do not, but I believe that the arbitrators are going to be surveyors, aren't they? So, you know, amongst the many other skills, they're going to have to get up to speed on being able to assess corporate viability in a very compressed timeline. Quite a tall order.
Okay. All right. Thank you. Let's press on with the next point that we wanted to raise. If I can get my questions up. Yeah, and I'd like to bring in Malcolm in terms of pensions. And I wonder if you can explain how you think restructurings insolvency may be affected by the new powers that the pension regulator has now acquired in relation to both imposing financial penalties and criminal prosecutions.
Yeah, sure. Just by way of background, I think it's worth observing that insolvency in the defined benefit pension world is incredibly quiet. Our financial year begins on the 1st of April. And so far, we've been notified of only 9 insolvencies since then, which is the lowest we've ever had in this period. So we are very quiet. Is that surprising? Well, most of the defined benefit employers, of course, are older companies. They've been through numerous economic cycles, but probably none of them have ever had the financial support that the government has provided this time round. So it's probably not that surprising that we're not seeing that many cases coming in. The ones that we have seen, they are basically businesses that have gone through their economic life, and they've literally just come to an end of it. Slightly bizarrely, rising interest rates now may help some of these employers. The higher interest rate means that the discount rate used on their future liabilities is higher, which means that those liabilities today are lower in today's money, and therefore the deficits are falling. And yeah, we publish a monthly aggregate of all the schemes we protect. And at the moment, if you added all those schemes up, they'd actually all be in surplus. Now, obviously, you can't set one against the other, but it does show an improving position in the defined benefit pension world. So provided nobody gets mega aggressive in trying to recover all this money that's been put out there by the government, I really can't see a massive increase in the world of defined benefit insolvency. What that means is there's been very few examples using the new CIGA methodologies. We've seen a couple of restructuring plans, neither of which have suggested doing anything to the pension scheme. Indeed, one of them put the pension scheme in an arguably much better position than it was in at the outset of the proposal. So so far, the experience has been good, and that may be something to do with the new powers that the regulator has. Nobody so far has tried to use a restructuring plan to modify a pension scheme, but we know it has been considered. We know people have looked at it. Is that because you can't easily use the CIGA methodologies on pension schemes? My personal view is I see it's pretty limited. If you were trying to perhaps change the deficit reduction payments, you could be scuppered very quickly, because the trustees the minute the plan has gone through, could call for a new valuation and put the contributions back. So yeah, that's my personal view. So it may be it's not a good tool for restructuring pensions. Indeed, I think that was the view of government, that there were enough other tools available to restructure pensions. Or it may be that these new powers are actually having an effect on people and making them think very carefully about whether to use them or not. Certainly from all the seminars and publications that were available during the course of last year, the legal fraternity thought there were some real risks. They may, of course, just be trying to scare all the employers into getting some very good advice, but who knows? But the new grounds for contribution notices of employer insolvency and employer resources, you look at the examples the regulators put out for those, and you can see that they are the points that have come out of a number of very well-known cases in the last 5 years of issues that have come out where the regulators almost had to use its powers. It hasn't had to because matters were settled, but wanting to stop those things. Are those new financial bits going to be used a lot? I think one of the issues is, as with all regulators, the TPR is resource constrained, so it's going to be looking very carefully about where it chooses to use those powers to make sure that that serious and obviously anything precedent setting is addressed. Turning to those powers and CIGA, I think TPR have said that they don't think that a restructuring plan approved by the court would be challengeable under the new powers. But of course, it just relates to the employer, perhaps the person being the subject of the restructuring plan. It won't relate to the wider arena that the regulator has the ability to go and ask for contributions. And you look to the rich friend rule for financial support directions there, and it's not going to stop that. So there is an opportunity still for the powers to be used. Turning to the penalties that are there, the civil and criminal penalties. Again, as I said, the resource issue, I suspect, will bite. If you're going to bring a criminal prosecution, you've got to get a criminal standard of proof, which we all know is very high and therefore is likely to be very expensive and resource hungry in getting there. I think with the civil penalties, where the proof is lower, that may prove the greater risk to people. And again, with the very wide ambit that they've taken to be able to go against an enormous number of advisors, as well as the company directors, whatever. And the only parties that are getting any help are insolvency practitioners, but that's only in the discharge of their duties as appointed insolvency practitioners. And of course, as we know, vast amounts of insolvency work these days is all done prior to the insolvency. So that is a real area of exposure. Again, are they going to be using these things widely? I think they will be very selective about how they use them because they haven't got the time or the resources to do it. But when they do, it will make a very clear point. And I think the reality is, like contribution notice and financial support directions that first came in, it's the threat of it that's the real issue, and that's the real controlling point. And I said we haven't seen the use of the insolvency, the CIGA powers in the DB world that much, but we have seen perhaps a change within the merger and acquisitions world. When the Morrisons takeover occurred, from what I understand, the pension trustees and the potential acquirers had proactive and sensible discussions, and proper and full mitigation, I understand, has been put in place on a voluntary basis between those parties that should see the scheme well protected. Would that have happened if that hadn't been at exactly the same time as those new powers came in? Who knows? But it does seem an interesting coincidence. But as far as the restructuring world is concerned, I've got to say, as my predecessor in this job used to say quite a lot, it's really still far too early to say.
But you know, the CIGA remedies do give interesting options, don't they, Malcolm, to restructure covenants that, you know, are challenged if they don't necessarily impact the situation with PPF and TPR. The fact that the DP deficit doesn't rule out those companies from being able to avail themselves of CIGA style solutions. So yeah, in a way, it's best of both worlds.
Indeed, as I said, with one of the schemes we were notified for a restructuring plan didn't actually progress in the end, but the very sensible discussions that the trustees had with the employer resulted, when the matter was settled, with the beneficial solution coming forward and improving the covenant. So it can be very positive.
Thank you very much. Just like to move us on to, I think, the last sort of major issue that we had set out for this debate, and that was the hot topic of regulation or reform of regulation for the insolvency profession. And Colin, I think I'll turn to you as president of R3 just to comment on that generally, and then we can bring other people in as well.
Gosh, well, this is not going to be a quick discussion, is it? President of R3 until about April, by the way. Flag it a bit now. Look, my personal view is that the one thing we're not short of in the highly regulated activity of insolvency work is regulation. We've got it in spades, and having worked for various different accountancy firms over the years, relative to other, you know, work streams that that are active, you know, we're very, very, very regulated. So my personal view is that having one regulator doesn't necessarily mean it's going to be a better regime of regulation than having several, two effectively we've got at the moment. But I sense that actually that ship has sailed. There seems to be an immovable agenda to moving towards one regulator. So I think R3's position, given that this is a very early stage of the consultation process, is that if there's going to be one regulator, let's make certain it's an improvement. And I've gone on record as saying that, you know, my problem with the current proposal is that, you know, commercial insolvency practitioners are going to bear the full brunt of the regulatory process. No problem with that. There's a cost, significant cost that goes with that. But parties that, you know, that will be in publicly funded employment, the official receiver is not. And it doesn't feel very appropriate to me. And at a time when it's important that the UK does everything it can to maintain the integrity and quality of its financial processes, which have been, you know, fairly well regarded in the global economy thus far. We want to ensure that we have a level playing field, and you can get certainty of outcome irrespective of whether the office holder is in public or private employment. So that's the bit I think needs to be thought about, in my humble.
Colin, can I just chip in as somebody who's very much an outsider to this? And one of the arguments I've heard put forward by some of the parliamentarians who've been involved in this is the need to get away from the public perception of a profession regulated by itself. And you know, yeah, I mean, the insolvency profession does at the moment largely regulate itself through the various bodies. There's no argument about that. But it's really struck me that self-regulation was one of the hallmarks, not a necessary one, but a hallmark of a developed profession. But secondly, that if the new single regulator is going to be, say, within or attached to, or in some way connected to the insolvency service, the issue that you've just touched upon becomes much more acute, because not only is there then the question of whether the official receiver is regulated at all. But there's the question of an institution connected with the insolvency service actually still regulating its own officers. So that would be absolutely no step forward and arguably a step backwards. Now, I don't know what is envisaged. I don't think any of us quite know what's envisaged at this stage, but am I being mischievous in that thinking, apart from my suspicion that a lot of what goes on in government these days is about fees and who gets the money, rather than about any real public interest matter, but we leave that to one side.
Yeah, look, it's a very interesting point, Stephen. From my point of view, or from R3's point of view, we've got no axe to grind as to whom the single regulator might be. All we want is an improved process. I think by iterative process, we actually arrived at a very robust regulatory regime in this country, which is the envy of many globally. And it would be a shame, wouldn't it, to flush all that down the tub, frankly. So it's a question of preserving the good of what we have and coming up with incremental improvement. And provided the outputs, the consultation process are reasonably and adequately considered, and they generally are, we'll end up with something sensible, I would have thought.
And I think a lot of the impetus behind this is the public perception of insolvency, and the public perception of insolvency, as often appears in the headlines of the Daily Mail or the Evening Standard, is a complete misunderstanding of what we do and how we do it.
Does regulation ever improve the public perception of I mean, estate agents are regulated now, aren't they?
Yeah, look, we did some research about a year ago, which provided some empirical data about how many people we keep in a job and how many companies are still going as a result of our members' efforts. And as far as I'm concerned, that is proper evidence of the value that we add to the UK economy. So I personally didn't find any of the arguments put forward in the APPG reports very compelling. A lot of it was based upon, I think, misconceptions around the way the market works. It may have worked 20 years ago, but it's not the way it works anymore these days, in my experience. The banks don't drive the restructuring process. The banks very often aren't in the restructuring process, because a lot of the deals that were funded by banks are now funded by debt funds, asset-based lenders, by other providers of capital. So the whole thing is basically, in my humble opinion, slightly misguided. But it seems to me that the agenda for a single regulator is not going away. So if we're going to have a single regulator, let's make certain it's a good one.
The point that Malcolm makes in relation to funding of public bodies to carry out regulation is a good one. At the time that government resources are really stretched, is there going to be proper funding to weed out the cowboys that that we know are there and have been weeded out through the processes over the years, but still one or two prevail? I mean, is there money? Is there going to be public money to deal with this?
Well, some of the cases that are cited as examples of problems with self-regulation, I would say, are great examples of self-regulation actually operating. The fact that people are brought to book and end up writing large checks as sanctions is a very good indicator to me that the regulatory process is working, actually.
Can I just chip in with a view as a buyer of the services and receiver of services? Yeah, my view for some time has been that a single regulator is a good idea. I think it should be self-financing. It shouldn't be reliant on government funds. But everybody on this webinar who's paying a license fee is already paying a lot of money that's going towards that within their own regulatory body. So I can't believe that if you have one body, you can't do that more efficiently. I'm quite sure these other bodies aren't doing it as charitable work. My experience of having to use the regulatory system has unfortunately not been good in recent years, where I don't think complaints are being looked at properly. I've got a situation at the moment going through, which is really most unsatisfactory. But I also look at things, one of the things that the consultation talks about is is compensation. And yeah, having been heavily involved in the Silent Night issue, where obviously it's well publicised, the fines that were imposed there. That whole case was based around how the pensioners have been disadvantaged by the actions taken by various parties. But that money's all gone to the regulator. So I think some rebalance there probably is appropriate and due, because that money could have made a real difference to those pensioners if it had gone to them.
Well, hang on, Malcolm. Can I just challenge that for a moment? Because if you're taken to court for a bit of shoplifting and fined, the fine doesn't go to the shop from whom you stole the handbag or whatever you were up to. It goes to the government. It goes into the state pot. Why should regulation? I think there'll be a victim's compensation payment to be made.
But what I'm saying is this regulation actually talks about consultation, actually talks about compensation.
Yeah.
So perhaps the balance should be to compensating the people who have been disadvantaged rather than fining. I'm not disputing your.
No, I wouldn't disagree with that either, Malcolm. I'd simply say there has to be a distinction, it seems to me, between a fine that's punitive and is designed to do one thing and compensation, which is a wholly different thing and might be subject to a different sort of burden as well.
Just chime in on a compensation point, if I might, guys. And it's a really interesting issue, isn't it? Because exactly who you're going to compensate. You're going to compensate the creditors in the insolvency, or you're going to compensate the legal owners of the business. There's a tension there, isn't it? It needs to be thought about quite a lot, I would say. Seems to me that, given the priority that we've had in this country since 1914, equity don't get anything if creditors paid in full.
I think it's the same tension, Colin, that still is not wholly resolved in relation to the Company Directors Act compensation, which was brought in without really much thought about who was going to get the money. And as far as I'm aware, there's only been one case, a very nicely decided one, I think, by ICC Judge Prentice, that dealt with it on the facts of that particular case. But if you're going to have fines and compensation, you need, I think, pretty clear rules, as you say, about who's going to benefit from the compensation and on what basis. With all the issues like contributory negligence as well, if you've got the shareholders who are the directors who did it, but a bit of very serious thinking, I think, needs to go into that.
Is that enough, Rob? We could go on.
No, I think that is fine. I just wondered if anybody wanted to mention in the small amount of time we have still available, anything that they wanted to mention before in relation to any of the other points.
I think Lee wanted to. Sorry, I know you're inviting the questions. Very briefly, Lee wanted to touch on the impact of CIGA on the SME community. We touched on this before. My passion is that the restructuring tool should be able to be used for small companies, because it's a fantastic tool, and at the moment it's only being used on very big ones, and the reported cases are on technical issues and not on whether they worked or not. But I think we saw this at the start of the administration in 1986, when the Act first came in. They started off being reasonably streamlined, and then the requirements of a Rule 2.2 report meant only the very biggest companies could afford to go into administration. I'm very keen that should not happen with the restructuring tool, that the reports that are done to work out what the relevant alternative and those important things for the court are maintained at a streamlined level to make it accessible to SMEs.
Well, I feel a lot better now that moratoriums are in fact a route to achieving it on the back of a CVA. The other, of course, good thing that flows from the moratorium with the CVA is once you send your notice out for the CVA proposals, you get an automatic extension of the moratorium until those proposals are voted on. So again, it's not as cumbersome. You know, if you get it done within your 20 days, you don't then have to apply for an extension, but you've got that extension by virtue of sending out that notice. And then, of course, if your CVA is approved, you know, gloves are off. You don't need the moratorium anymore because you've got protection. So, you know, I'm becoming increasingly comfortable with that as, you know, as a route for SMEs to do that via moratoriums, followed by or in tune with the intended CVA. That should be able to address most issues.
Does that extension go all the way through the challenge period as well, automatically?
I think it would do, because by virtue of the fact that it's effectively allowing you to get your protection to the point where the CVA is approved. If the CVA is approved, it's deemed approved, albeit subject to challenge. So effectively, the CVA has been voted on, it's been passed. If there's a challenge, then you've got to work backwards anyway, and that can take forever. So I don't think you're exposed in terms of a monitor being exposed on the liabilities that are incurred post the approval of the CVA, albeit that CVA being subject to challenge. If the challenge is successful, then it's gloves off and the whole thing probably goes to the next stage, which is some sort of insolvency process. And then I guess what you'd have to do is to make sure, as you would have done, that up to the date of the CVA being approved, you've got enough to meet those expenses anyway, because that doesn't fall away by virtue of the fact that you've got a CVA that's approved if it is subsequently thrown out by way of a successful challenge. So that's what, you know, the key task for the monitor is to make sure that there is enough cash in any circumstances, or enough by way of realizable assets to meet those liabilities that accrue during that period.
Colin, you wanted to say
something? Guys, we've all been around for a while, haven't we? And I think we'd all, I share your passion, Jeff, and I think the interesting thing, the most exciting bit about CIGA is it gives us yet more options. We've got a real smorgasbord of tools now, haven't we? Kit that we can deploy, really helpful. You know, there's a debate going on right now whether or not CIGA and the arbitration process is going to see off CVA. Personally, I don't buy that. I think CVAs will continue to be a highly useful and highly flexible bit of kit. I accept that the RP gives certainty from the moment the judge, you know, hits the bit of wood, and we don't have to have the agonising 28-day wringing of our hands in the challenge period. But there's still going to be situations where I think CVA is going to be very useful. I think it may or may not be retail, but there's a bunch of businesses out there with leasehold estates that aren't in retail, and some of those are going to need to rationalise their situations. So I think, you know, we've got some really useful optionality, and the fact that Lee has now single-handedly proven that moratoriums can be used for SMEs and mid-corporates is fantastic news, because I love to win an argument.
Thank you so much, Colin. I think our allotted hour's time is about to run out, but so I'd like to thank everyone, all the participants on our panel for joining us, and yes, thank you very much. I think it's been a very useful discussion, and thanks for joining us.